2025, please come to order. First thing is reading of the minutes. Does anybody have any corrections or additions? Not, may I please have a motion?
I move that we adopt the minutes of June 4th.
I second.
Questions on the motion? All those in favor, please signify by saying aye.
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 Any members of the public in the audience who would like to make public comment? There being none, we'll move on to the consent agenda. Very long one today. Is there anything anybody would like removed or changed? Are there any questions?
Madam Chair, I move that we adopt the consent agenda as presented.
I second the motion.
Questions on the motion? All those in favor, please signify by saying aye. Aye.
Aye.
Aye.
And now we are on to the regular agenda. The first item is the matter of application of DP&L for authority to implement a DSIC rate for natural gas distribution. Who do we have? Brian Jordan for DP&L.
Thank you, Acting Chair. Commissioners, may it please the Commission, Brian Jordan for Delmarva Power and Light Company. And thank you for the opportunity to address the Commission on this matter. I had requested to address the Commission because it involves some unusual circumstances. And to be clear, we are not challenging or disputing the order. We support the order, but there's an unusual circumstance behind it. We filed this gas DSIC while gas-based rate case was pending. And in that case, the test period ran from April 1, 2024 through March 31, 2025. That overlaps with the current DSIC period that ran from November 1, 2024 through April 30th, 2025. So consequently, this gas DSIC application only seeks recovery for closings that took place in April 2025. That's the only one that's not covered by the test period. Ultimately, this application seeks to raise the DSIC from 0.00% to 0.03% effective July 1, 2025. So for an average residential customer using 77 CCF in a winter month, this will result in a monthly increase of about 2 cents. Now, this DSIC period also included an undercollection of $503,679, and that's the unusual circumstance. Overlapping test periods and DSIC periods are not unusual, of course, but with this pending rate case, we implemented interim rates on April 20th, 2025, which happened during the DSIC period. That is unusual. It had occurred once before in docket 210408 and in a prior DSIC predecessor, the UFRIC docket 15-1011. In 2021, DPL unsuccessfully argued to the Commission that the only way to interpret the DSIC statute was to always include an under or an over collection in its application. But staff and the Commission disagreed, ultimately finding that the statute does not allow a utility to carry an over or under collection true-up after a DSIC is reset when new rates go into effect as a result of a base rate case. That was a lot, so I'm going to say that one again. The ultimate finding was that the DSIC statute would not allow a utility to carry an over and under collection like we have here, true up, after the DSIC is reset when new rates go into effect, which happened for our rate case on April 20th. So as a result, I just wanted to make clear to the Commission that although there was a $503,679 under collection, that does not show up in this application. So if you're looking at the numbers and you're curious of why that's not in there, the reason is we're not allowed to carry it forward. You're welcome. Happy to take any questions.
Mr. Jordan, a couple of questions. First of all, wouldn't that 503,000 be incorporated into that rate case?
It would ultimately get picked. So short answer, yes. So we're not double dipping and collecting, or even if it was an over collection, refunding it twice.
Okay. And secondly, you said 77 CCF is the average usage residential. And is that, that's a change because for 10 years, I've heard 80 CCFs pretty much across the board. So are those numbers being recalculated each year to fully determine the average usage, and that's why it's lower now. And does that include only home heating, or does it include things like grills, fireplaces, generators, stovetops?
So, Commissioner, that's for the residential, and it is 77 in the and that's for the winter, in a winter month. We always face the difficulty with gas, whether we include the calculation for just the winter month when gas is primarily used, or if we try to average it over the whole year, in which case, you're going to have that imbalance, heavy winter use, low summer use. And I think with that one, it's typically a 56 or 53 CCF. But, for this one, this period covered the previous winter one, so the comparison would be apt to use, again, the winter, the 77 CCF when it's more frequently used.
And again, that's just for heating or for all,
I believe that's just that's
Appliances.
residential, so
all appliances?
I believe so.
Okay, thank you.
You're welcome.
Thank you.
Questions? All right, Ms. Workman? Staff?
Staff approves the form of the order, proposed order number 10742, and recommends that the commission adopt it.
DPA also approves.
Further questions from anybody? May I have a motion, please?
Move that we adopt proposed order 10742 as presented.
I second.
All those in favor, please signify by saying aye.
Aye.
And on to number 2. In the matter of the application of Chesapeake Utilities Corporation for a new rate schedule, TBFF, called Town of Bridgeville Franchise Fee Rider, and other updates to the company's franchise fee rider tariff pages. Who do we have? Mr. O'Brien.
Excuse me. Thank you, Madam Acting Chair and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities Corporation. In April, Chesapeake renewed its franchise with the town of Bridgeville, and this time the franchise includes a 1 cent per CCF franchise fee to be recovered from customers within the town and then paid to the town. Proposed order number 10747 is the opening order in this docket, which is Chesapeake's application to add the 1 cent fee to its tariff for town residences and businesses. The order directs the company to publish notice of its application and sets a hearing date of July 23rd, 2025 before the Commission. We respectfully request that the Commission enter the proposed opening order number 10747. Thank you, and thank you to staff for its work on this. I do have Michael Reno here if there are any questions. He's also here for a evidentiary hearing that we have later. He's our new regulatory manager in Delaware. Thank you.
Any questions? Okay, Mr. Ferguson.
Good afternoon, Stephen. Staff supports the entry of the proposed opening order. Did the commission adopt order number 107?
Thank you. Mr. Fowler?
DPA also recommends it be adopted.
All right, we'll need a motion then.
I move that the commission adopt order number 10747 as submitted.
I second the motion.
Questions on the motion? All those in favor, please signify by saying aye.
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 Any opposed? Motion carries. Number 3 is,
Thank you.
thank you, guys. In the matter of the application of Tidewater Utilities for a general increase in rates. Okay, we have Pam Scott representing Tidewater.
Thank you, Madam Acting Chair and Commissioners. Pam Scott here on behalf of Tidewater. You have before you a joint motion on behalf of Tidewater Public Service Commission staff and the DPA requesting the de-designation of the hearing examiner in this matter, as the parties have reached a settlement in this rate case, and we propose that that settlement be submitted directly to the Commission at their July 2nd hearing, for which public notice has been provided.
Thank you very much. Any questions? Ms. Workman?
Public notice for the potential hearing on July 2nd was published on June 2nd, so it gives us the 30 days notice that we need to have this hearing. And like Pam said, all the parties agree. We think this settlement is in the best interest of the customers, and are all ready to go forward and present our evidence to the commission. And for that reason, we request that the commission approve order number 10748 to revoke the delegation of the hearing examiner and grant approval for us to present directly to the commission on the July 2nd meeting.
Nothing further to add. The parties are in agreement that it's in the best interest of the company and all Delawareans.
May we have a motion, please?
I move that we adopt order numbers 10748.
I second.
Questions on the motion? All those in favor?
Aye.
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 Any opposed? All right, on to number 4, in the matter of revision to the rules of practice and procedure of the Delaware Public Service Commission, PSC Regulation 1001. Ms. Workman.
Thank you. Staff submitted a petition to amend the rules of practice and procedure of the Delaware Public Service Commission, which is codified at 26 Del Admin Code 1001, to remove the requirement of a court reporter to transcribe hearings and update to the new style guide published by the Registrar of Regulations. Staff believes that this change is necessary because a couple meetings ago, the commission held a hearing without a court reporter, and upon further review of the regulations, we're not supposed to do that. Ultimately, the hearing, we were able to transcribe the hearing from the Zoom recording, which worked well, but according to the rules, we messed up. So to avoid this situation in the future, I've reviewed the applicable laws in both the Public Utilities section of the code and the APA, the Administrative Procedures Act, and there's no requirement for a court reporter to transcribe as long as they're transcribed and some way. So to avoid any issues in the future, we've amended the rules to remove the necessity of a court reporter. The court reporter can still, they're not barred, and I believe the plan is to continue to use court reporters. It's just to avoid having a future issue. And staff respectfully requests that the commission adopt proposed order number 10749, reopening the rules of practice and procedure of the Delaware Public Service Commission, and to publish the proposed amendments to the Registrar of Regulation. Thank you.
Any questions?
Yes, I have a question. Are there other commissions in the state that are not using court reporters or who are using court reporters but don't have that requirement codified?
Most do not use any court reporter at all. A lot of times when there are hearings, they will use a court reporter or a transcription service. But for the most part, it's very abnormal in our state that we have a court reporter at every meeting doing everything. I do think it's important for us to have a transcript of hearings in case there's an appeal that needs to happen. That's something we would want to provide to the courts. But yeah, we're the weird ones here.
It just underscores the importance of the Public Service Commission.
Absolutely.
Any other questions?
Yeah. So where will the responsibility for transcription reside if we don't have a court reporter?
So luckily, previously, we did not have Zoom, but we've recently started using Zoom, which provides us a transcript. Well, it doesn't provide us a transcript, a recording, and then we can contract with a transcription service to provide a transcript for us that we can put in the docket with the hearing. And that's what we did last time, and we were able to get away with it because the attorneys are also nice, and they agreed to proceed without a court reporter the day of. So we will have a method for getting transcription done, even if it's not by a court reporter.
Further questions? Thank you.
Please.
I move that we adopt order number 10749.
I second.
Questions on the motion? All those in favor, please signify by saying aye.
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 Any opposed? All right, and we are on to number 5. Excuse me, in the matter of adoption of rules to establish an excavation damage prevention program. And this was opened in 2019. And again, Ms. Workman.
Back again. Staff has submitted a petition to the commission requesting to reopen and amend 26 Delaware Admin Code 8002, which are the rules to establish an excavation damage prevention program. Staff believes the amendments are necessary for 2 primary reasons. First, currently the regulations require payment of penalties in a way that does not follow the policy of the state of Delaware. Specifically, the state of Delaware requires checks over a certain amount to be cashed within 1 day of receipt, while our regulations currently force staff to hold on to checks for sometimes weeks until the commission can approve a consent order. And so what we're trying to do with the regulations is match those 2 up so that any payment doesn't happen until after the commission has approved the order, so that as soon as we get the check, we can deposit it to the state fund as we're supposed to. Second, the current setup of the rules is not very clear. There are a lot of lists that currently in the regulation just appear as paragraphs, and it's not very clear at first glance what exactly is expected of both the commission, staff, and respondents under this regulation right now. And so I think this is especially important because a lot of the times these regulations need to be interpreted by excavators, and they're not legally sophisticated. They aren't represented by counsel a lot of the time. So I want to be able to make it very clear what's expected of them if they're getting these letters saying you've done something wrong, and we want to make it very clear what their responsibilities are. And so a lot of the information didn't change. A lot of the changes are based on the format so that it's more clear to a person who's looking at it exactly what they need to do. For those reasons, staff respectfully requests the commission adopt order number 10750, reopening the rules to establish an excavation damage program and to publish the proposed amendments in the Register of Regulations. Thank you.
No questions, Madam Chair. I'd like to move that the commission adopt order number 10750 as submitted.
I second the motion.
Questions on the motion? All those in favor, please signify by saying aye.
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 Thank you. All right, in the matter of the petition of the Public Service Commission staff and Delaware Division of the Public Advocate to establish a regulation for distribution system investment plans for Delaware Electric and Natural Gas Utility. And who do we have to, Mr. Ferguson?
Staff and DPA jointly request that the commission waive certain regulatory requirements for the 2025 ISR plan year because it is not a good use of staff and DPA time and resources under the current ISR plan process. In PSC docket number 230460, staff and DPA provided comments that they do not find the ISR plan process to be collaborative and productive as envisioned when the regulations were published. Last year, under PSC order number 10375, the commission waived certain requirements for the 2024 ISR plan year to allow for time for the regulations to be amended to improve the ISR plan process. In July 2024, proposed amendments to the regulations were published. However, staff and DPA then jointly requested that the commission take no action on them until the commission decided Delmarva's alternative form of rate regulation application, and that was in PSC docket number 240868. Delmarva recently withdrew its AFRR application, so staff now intends to revisit the proposed amendments to the regulations to improve the ISR plan process. But since the amendments will not be finalized in time for the 2025 ISR plan year, staff and DPA asked that the commission waive the same requirements as they did in 2024. Specifically, the requirement that staff and DPA meet and confer with Delmarva twice after the filing of Delmarva's proposed ISR plan, and also waive the requirement that staff and DPA file comments on the proposed ISR plan and that Delmarva file reply comments. And those requirements are found at 26 Delaware Administrative Code, Section 3007-6.3.1, 6.3.3, and 6.3.4. Delmarva did file its proposed ISR plan for 2025 on March 31st, 2025, and will file its final 2025 ISR plan within 120 days of that date. I'd also note counsel for Delmarva had no objection to the proposed order that's before the commission. And for those reasons, staff will request that the commission adopt order number 10751. Thank you.
Brian Jordan.
Good afternoon again, Acting Chair and Commissioners. Brian Jordan for Delmarva Power and Light Company. Mr. Ferguson is correct that Delmarva does not object to the entry of the order. We certainly look forward to submitting comments on the proposed changes to the electric ISR regulations, and we will pick it up where we left off last year.
Mr. Crumpler.
Nothing further to add based on what Mr. Ferguson already commented on.
Are there any questions?
Yeah, Madam Chair, yes, I have one question for staff. So it looks like some requirements were waived last year, 2024, and we're being asked to waive requirements again this year. And so my question is, several steps in the process have been waived now, a couple of years in a row, well, perhaps a couple of years in a row. When will the rules be finalized? There was nothing, I would say, in the supporting information that indicated a schedule to get to the end point, which now has been deferred a couple of years.
Staff would anticipate the final regulations would be in place for the 2026 ISR plan year.
Okay, thank you. No further questions, Madam Chair. I'll make a motion that the proposed order 10751 be adopted by the commission as submitted.
I second.
Any questions on the motion? All those in favor, please signify by saying aye.
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 Any opposed? Thank you. All right, now we are up to number 7 in the matter of the application of Chesapeake Utilities Corporation for a general increase in its natural gas rate and for approval of certain other changes to its natural gas tariff. And we have Mr. O'Brien.
Thank you, Commissioner Conaway and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities Corporation. I have with me Matt Evergam, AVP of Regulatory Affairs. Matt testified in support of the proposed settlement at the May 6th evidentiary hearing in this matter before hearing examiner Glenn Kenton. What you have before you is proposed order number 10753, which will approve new natural gas base rates for Chesapeake Utilities. The last time we were before you with a proposed order approving new base rates was in December 2016, when we all looked a little different. Some things are not different. We have a proposed settlement agreement, and we have a hearing examiner's findings and recommendations recommending that the commission approve the settlement agreement. And no party has filed exceptions to the hearing examiner's recommendations. One thing that is different is that this order does not discuss any refunds to customers, which are required when the final approved rates are below the interim rates in place. The parties were able to settle the revenue portion of the case just before the full interim rate was set in March, so we were able to match the requested interim rates to the settled rates. Another thing that is different is that the proposed settlement before you today only resolves the revenue portion of the case, including new depreciation rates and a couple of other items. If you approve the settlement, the rate design and other tariff changes will be pushed to a phase 2 of the rate case. The phase 2 will also address our proposed weather normalization adjustment, which is a form of decoupling that backs out of a customer's bill part of the effect that abnormal weather has on the customer's gas usage. Another thing I'd like to mention is that while all rate cases involve piles of discovery and maybe a couple of settlement conferences, this case involved much more live interaction between the parties in the form of multiple discovery conferences and individual calls where the expert witnesses hashed out their understandings of the financial schedules. And it involved multiple settlement conferences. So for that, I'd like to thank staff, staff counsel, and staff's consultants, as well as the public advocates staff and their counsel and their consultants. You've read the hearing examiner's report, so we won't go into a lot of detail regarding the settlement today, but I will say that the revenue increase from the settlement is $6.1 million based on a 9.6% return on equity. The company's original request was $12.1 million, which went up to $12.9 million when the schedules were updated for actual data over the full test period. Another item is that the company withdrew its request for a technology cost recovery rider. The company also agreed to forego recovery of rate case expense incurred in phase 2 of this proceeding, which would likely be a significant number. One last thing. For a typical residential heating customer, the $6.1 million increase adds about $5.37 to a monthly bill in the winter, or about 6% of the bill. A non-heating residential customer will see about $2.74 per month increase, $2.74 per month increase, or about 6.5%. With that, the company respectfully requests that the Commission approve proposed order number 10753, which will adopt the hearing examiner's recommendations, approve the proposed settlement, and then we'll be on to phase 2. Thank you.
Any questions? Mr. O'Brien?
Yes, Madam Chair. So, Mr. O'Brien, I had written down on my paper weather normalization adjustment ? And I know you mentioned it, but can you spend just a couple of minutes to elaborate what that means, how that works?
Thank you, Commissioner Gray. One reason I threw that in there was because I did see on the agenda today that later under the director's comments that you might be discussing Delmarva Power's bill stabilization adjustment on the electric side that they have in Maryland. So I did throw that in there because it is a form of decoupling, just like the BSA is, that seeks to separate the company's revenues from the customer's usage. This is something that Chesapeake has been proposing for several years we proposed it in our last rate case, and we got pushed out of that. We proposed it in a separate docket, and then it got pushed into this docket. So it's been pushed once again, but to a phase 2 of this docket. So it's a way of isolating abnormal weather out of the bill impact, at least on the distribution side. It doesn't affect the gas supply side, or what we call the GSR. So, there is testimony in the record right now from our consultant on this matter, which is Ron Amon from Atrium Economics. So that is part of the record. So I do feel comfortable discussing it with you somewhat today, even though it will be perhaps litigated in the next phase. But that's what it is. It's a decoupling mechanism that brings bills down in a harsher than normal weather and takes bills up in a warmer than normal weather.
Understood. Thank you. And I did hear you say, I think that this topic is a part of the second phase of this proceeding, right?
Yes, I would say it's a big topic.
Okay, very good. Thank you. No further questions, Madam Chair. Thank you.
Staff agrees with the proposed order, and we went through a whole hearing with hearing examiner Kenton. He asked some questions of the witnesses, and ultimately he determined that the settlement agreement was fair, just, reasonable, and overall in the public interest. I think an important part of the finding is that Chesapeake hasn't had a rate case of this kind since 2016, and they are, inflation and all the other 1,000 factors that the accountants take into effect have raised costs. And so they felt it necessary to come in, but they waited for a while before they came in, which I know staff appreciates. But the findings and recommendations of the hearing examiner, staff has no objections to, and we all believe that the terms of the settlement are just and reasonable, and we recommend that the commission adopt proposed order number 10753. Thank you.
Yay, welcome back, sir.
Thank you, Madam Acting Chair. Frank Murphy of Murphy and Landon, Division of the Public Advocate. The division put a lot of time, effort, and resources into this case. We had two experts, witnesses who evaluated the application of Chesapeake Utilities, and both of them testified at the hearing on the settlement before the hearing examiner. And the conclusion is that the settlement is just, fair, and reasonable. And we ask also that the commission approve order number 10753. Thank you.
Any questions of Mr. Murphy? Motion then, please.
Madam Chair, I move that we adopt order number 10753 as submitted.
I want to second that, and I want to comment that we all appreciate all of the work staff has done, all of the work the DPA did, Ms. Workman, all of the work that you did, and of course the company. And most importantly, our hearing examiner, who did a lot of work. But for everyone, we do appreciate that you all worked so hard to get this done. And you've given us a lot of information, the hearing examiner's information, the settlement agreement, that we could understand. And understand that this, while we don't want to do anything that's going to increase the base rates for your customers, this is a well done settlement agreement, and it was well negotiated. So we appreciate that. So I will second the motion.
One more statement, Madam Chair, and kudos to the company for waiting so long.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Aye. Motion carries.
Thank you.
Thank you. Now, hearing schedule. Ryan, don't go too far. The matter of Chesapeake Utilities Corporation for approval of its energy efficiency rider rate be effective May 1st, 2025.
Thank you, Madam Acting Chair and Commissioners. As you're aware, this is the evidentiary hearing on Chesapeake's application for approval of a change in its energy efficiency rider rate. After we put our evidence into the record, we'll be asking you to enter proposed order number 10754, approving the new EER rate. The Commission should have the exhibit log listing 3 exhibits. It is my understanding that staff agrees with the exhibit log as far as admissibility of the exhibits. I did not mention DPA because I do not believe they intervened in this case. So therefore, I would like to offer those exhibits into evidence from the exhibit log. Exhibit 1 is the company's application. Exhibit 2 is the direct written testimony of Marie Kozel, including all schedules and exhibits, which will be adopted by Michael Reno in a bit. And then Exhibit 3 is the proof of publication of notice of the application and the hearing that was filed on May 29th, 2025.
Accepted. Thank you.
The company calls its first and only witness, Michael Reno. This is his first time testifying live before the commission, so I am going to ask him a little bit about his background, but I do ask that he be sworn.
Yes.
Please state your name, business address, and position with Chesapeake Utilities.
My name is Michael Reno. My business address is 500 Energy Lane, Dover, Delaware. I am a regulatory manager with Chesapeake Utilities.
Have you testified before this commission in any prior cases?
Yes, I provided testimony in Chesapeake rate case, docket number 240906.
This is your first time testifying live, is that correct?
Yes.
Please summarize your background.
I received a bachelor's in accounting from DSU in 2016. I have been with Chesapeake since 2017 and working in various corporate finance departments within the company. In 2019, I joined the regulatory affairs department as an analyst, in which I served the various regulated business units underneath the Chesapeake Utilities Corporation umbrella. My duties have included establishing new regulatory programs, including receiving commission approval for establishing capital projects, preparation of routine and non-routine special projects, including rate proceedings. And in 2015, I was promoted to a regulatory manager.
Did you mean 2025?
2025.
What has been your assignment in this docket?
My assignment in this docket was to help with the calculation of Chesapeake's proposed energy efficiency rider rate to be effective for service rendered on or after May 1st, 2025.
In connection with that assignment, did you help prepare and file on March 31st, 2025, an application for approval to implement a new rate under the company's EER tariff provisions?
Yes.
In connection with that assignment, did you submit your own pre-filed testimony in this case?
No, for purposes of this hearing, though, I am adopting the testimony of Marie Kozel.
So would that be Ms. Kozel's direct testimony admitted into evidence as exhibit number 2?
Yes.
If I were to ask you today the questions set forth in the pre-filed testimony you are adopting, would your answers be the same?
Yes.
Is the information set forth in the application and the schedules to the application and the pre-filed direct testimony you've adopted true and correct to the best of your knowledge?
Yes.
Can you briefly describe how the EER calculation is made?
Yes. The EER recovers the costs associated with Chesapeake's 3 approved residential energy efficiency programs, which are implemented in partnership with the SEU or Energize Delaware. The costs included in the balance currently in the regulatory asset approved by the Commission in 2016. For a project year, recovery is based on the approved budgets and forecasted sales amortized over 3 years. And there's a true-up for any over or under collection from the prior year. The calculation is described in more detail in my written testimony.
Do you believe that the proposed EER rate of $0.0109 per CCF was calculated in conformance with Chesapeake's tariff at rate schedule EER and the Commission's order number 10441 approving the EER calculation?
Yes.
What impact would the new EER rate have on a typical residential customer?
An average residential heating customer using 700 CCFs per year will experience an annual increase of approximately 0.25% or $2.82. During the winter heating season, average residential heating or customer using 120 CCFs per month will experience a monthly increase of approximately 0.284% or 49 cents.
Thank you, Mr. Reno. I have no further questions at this time. Mr. Reno is available for cross-examination or any questions from the commissioners.
Staff has no questions.
Next.
All right, thank you. Staff would like to call our first and only witness, Ms. Shauna Marshall. And we would ask that she be sworn in.
Yes.
Please state your name and business address for the record.
Shona Marshall, 861 Silver Lake Boulevard, Cannon Building, Suite 100, Dover, Delaware, 19904.
By whom are you employed?
The Delaware Public Service Commission.
What is your position with the commission?
Public Utility Analyst.
And in connection with your employment, have you performed certain review and investigation in this docket?
Yes.
Can you briefly describe the application?
Yes. Chesapeake filed an application on March 31st, 2025, seeking an increase of its current energy efficiency rider surcharge from .0069 per CCF to .0109 per CCF. The energy efficiency portfolio consists of 3 programs: the Home Energy Counseling, Home Performance with Energy Star, and Assisted Home Performance with Energy Star. On April 23, 2025, the Commission entered PSC Order Number 10690, which permitted the proposed surcharge to become effective May 1, 2025. Additionally, the order set forth the public comment and intervention periods of this docket.
Were any intervention petitions filed?
No.
Were any public comments or objections received?
No.
Did you participate in quarterly meetings on behalf of commission staff for the purpose of discussing the status of Chesapeake's EE programs as required by PSC Order Number 10441, issued May 1st, 2024?
Yes.
Chesapeake filed an application on May 15th, 2025, seeking a 1-year extension of its energy efficiency program, which was approved in docket 231175. It was approved at the May 28th commission meeting. Can you summarize the application and staff's recommendation?
Chesapeake began implementing its program in the fourth quarter of 2024 during the final 2 years of the 2023 to 2025 program cycle, recommended by the Energy Efficiency Advisory Council. As of December 31st, 2024, Chesapeake's combined participation across all 3 programs fell short of forecast with just 29 participants. Additionally, net savings were 125.56 MMBTUs, while Chesapeake incurred costs totaling $107,270.76. Staff supported Chesapeake's request for a full 2 years of data and reporting to properly assess the program, as well as align its energy efficiency program cycle with the program cycles of other regulated utilities in Delaware.
What's your recommendation to the commission?
With the recent approval of Chesapeake's program cycle through 2026, I believe the Commission should approve the energy efficiency surcharge increase of .0109 per CCF as final. Given the short program length at the time of filing, it is not possible to accurately assess the effectiveness or efficiency of Chesapeake's energy efficiency programs. After 2026, there should be enough data to support an opinion on Chesapeake's conservation efforts. As such, staff respectfully recommends the Commission approve the application as submitted.
Thank you, Ms. Marshall. Ms. Marshall is now available for any cross-examination.
No cross from the company. Thank you.
EPA was not part of the case, but I have no questions.
Move that we adopt proposed order number 10754 as presented.
I second the motion.
Those in favor, please signify by saying aye.
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 Thank you very much.
Thank you.
Now on to administrative matters.
Thank you, Madam Acting Chair. First, under administrative matters, we wanted to have the Delmarva talk about their bill stabilization adjustment. You may recall Commissioner Gray asked about that in our February meeting, I believe, and subsequently Commissioner Gray, some staff members met with the company and they reviewed that, and he suggested that the entire commission hear the presentation. So that's why we're here today with Ms. DeVito and Mr. Jordan.
Good afternoon, Madam Chair and Commissioners. Susan DeVito on behalf of Delmarva Power. We do have a slide presentation today, so hopefully you all received it in advance. So what we're going to talk about today is revenue decoupling, and then we'll talk about how it operates in our Maryland jurisdiction, specifically Delmarva Power, Maryland. And, we'll talk about the history of it, why it was enacted and how it operates. I think it's really important to talk about like some of the, math homework behind it. So if you move to the next slide, revenue decoupling is generally, you can go to the next one. That's just kind of like a quick agenda. But what it is, it's a rate making mechanism designed to eliminate or reduce the dependence on a utility's revenue on distribution sales. It kind of breaks the link between the two. So as Mr. O'Brien talked about today, a little bit about the weather normalization adjustment, that too is a form of decoupling, but that just focuses on the weather specific. Full decoupling utilizes or focuses not only on weather, but also energy efficiency programs. So it makes the utility basically indifferent to selling less product and improves the ability of energy efficiency and distributed generation programs to operate within the utility environment. It's designed to better motivate utilities to consider all options when planning and making resource decisions on how to meet their customer needs by, again, removing that sales link in the current rate design. Breaking that link between utility sales and revenue removes both the incentive to increase electricity sales and the disincentive to run energy efficiency programs or invest in other activities that may reduce load. So utility decision-making focuses on delivering reliable service to customers even when such investments reduce throughput, like, for example, energy efficiency and DER. The result is better alignment of shareholder and customer interests to provide more economically and environmentally efficient resource decisions. So if you move on to the next slide, revenue decoupling recognizes that costs associated with delivering electricity for the most part are fixed, thus enabling base distribution rates to recover the appropriate level of fixed costs in the face of fluctuations of usage. So it's just interesting to note that either full or partial revenue decoupling is approved in every jurisdiction in the United States except for the following: Alaska, Delaware, Florida, Iowa, Nebraska, West Virginia, and Wisconsin. So moving on to the next slide, this kind of talks about when we got approved for decoupling in our other jurisdictions, in the PHI service territory, specifically in Pepco, Maryland and DPL, Maryland. That was approved in 2007. And we had two orders, both reduced, both of those, their ROE by a 50 basis point reduction, but all of that has since been removed. Actual versus targets, so we'll talk about that when we get into the discussion of how it actually operates. But so actual versus targets are reviewed and customer rates are adjusted on a monthly basis, either up or down based on, if we've collected too much revenue based on the targets versus what the actual billed revenue is. So it compares two different things. In DC, we were approved for the BSA back in 2009, again with a 50 basis point reduction to Pepco's ROE. However, that too has since been removed. Actual versus target rates there are adjusted annually now based on the most recent order in DC in their multi-year plan. So in our New Jersey jurisdiction, decoupling began in July of 2021, and it's called our Conservation Incentive Program. There was no direct ROE adjustment, and actual versus targets are reviewed monthly, and customer rates are adjusted on an annual basis. And as we mentioned, there are other forms of decoupling, like the weather normalization adjustment, which affect the weather component of the bills. And I'll stop there because I know I've said a lot, so.
I do have a question where you say that the adjustment is made annually to the customer's bill. Let's say the customer owes more, is that amortized over the following year, or is it all billed on a 1 month as due within the next following month of that year?
It goes in for an annual year, so for 1 year. So that they get reset, they get reviewed. Like for New Jersey, for example, we do the calculation every month and then accumulate it over 12 months. Then we have an official filing, those get approved, and then they go in for the next 12-month cycle.
I presume that there are no complaints and or no requests from the customers. Am I correct?
Complaints?
Complaints about this method of adjustments, decoupling.
I mean, I can't say yes or no. I don't work in the customer service department, but I would say that this has been, especially in the Pepco region, have been, ongoing for so long that customers have adapted to it. And we haven't had any complaints directed at us in New Jersey since we've had it implemented. I mean, Brian, are you aware of anything specific that you can speak to?
No, Commissioner, I'm not aware of anything specific, but I'm certainly happy to take it back and ask and follow up with the commission if there are complaints specifically directed towards this program.
No, I would just be very surprised if there were no complaints from customers. I mean,
My question is that you mentioned that this is an alignment of shareholder and customer interest, but I can't imagine shareholders would be as receptive because of the de-emphasis of sales. And so is it more that there is offset by the consistency that this provides versus the potential reduction in sales?
So it does provide stability, and I think that's really what shareholders are interested in, right? The fluctuations in weather up and down, that doesn't kind of doesn't feel very well for shareholders, right? So they like that consistency, and I think that's where the benefit for them comes into play.
Do you sense this also brings a consistency to the customer? For instance, weather fluctuations during, let's say, winter months. Does this normalize or make the customer pay a more average rate month by month?
They would pay what I would say a weather normalized rate, right? So the way that rates are set, and this is kind of very technical, but they get set on a weather normalized basis, right? So over the 30-year weather would be what rates are set at. So to the impact, positive or negative, right? So it does go both ways, that customers would benefit. And you'll see when we go through the simulation that I have for DPL Maryland, that there were refunds that customers got in certain months from this past winter. So I think you'll see that when we kind of go through that example. That's why I think it's really important to see, but it does go both ways, right? So there are some months that the customers pay, but there's also months that customers do get a refund.
And that is in the scenario where you're adjusting month by month. If you're doing it annually, then you just normalize and make this more of an average rate the following year?
Yes. So, but I think that's maybe confusing to customers, right? Because they could have had a really cold winter, say in January, but if you don't reset the rate for 12 months later, customers can't associate that positive or negative rate with that 6 months ago weather event, right? So when it's close to, the way Maryland works is it's very close to when the actual weather event happened, and then it moves it to 2 months out, but at least customers can relate it to that potential weather event. Okay, so if you go to the next slide, again, sorry for all the numbers, but I think it was important to really talk about like how months fluctuate. And I'll talk about, I highlighted some of the numbers, and you'll see just going to line 2, I probably should have highlighted this one, because this is where the actual, class base revenue targets are set, and they're based on a rate case, and they're based on the test year that was approved. So those, the 7886, the 10686, you can see they vary per month because they're weather normalized, right? So things happen in those months that cause some of them to be higher or lower. So basically, it takes the number of customers, multiplies it by this class-based average revenue per customer that was approved in our rate case, and says this is the amount of revenue that would be allowed, to be collected for that month. So I'll use January because December has some previous numbers in there that kind of carries forward a balance. But you'll see in January, we had 187,000 customers. The average class-based revenue was $106.86 for an allowed revenue of $20 million. So based on billing information, it was a really cold January, as we all recall. The actual distribution revenue that was billed to customers in that month was $20.7 million. So that difference between the actual billing and the allowed revenue was different by about $700,000. And again, you can see there's a carry forward. So the total revenue adjustment to customers in that month was about $878,000. It then gets basically divided by forecasted sales and come up with a rate. So those customers got, now it was in January, but they didn't get it till March because there's timing things that happen, but got about a $3.59 return or like adjustment on their bill back to them. Now, again, based on usage, this is based on 811 kilowatt hours, so it's an average customer. But that's what they saw in that month of March because it takes time. You have January billing. The calculation happens in mid-February. Then it actually goes on customers' bills beginning March 1st. So there is some time lapse between there. And then you can see February, same thing. February, there was a $9.65 refund to customers based on the difference between the allowed revenue and the actual billing revenue. I'll stop there. I won't go, but you can see it goes on for months. Every month, this calculation happens. If you go out to Maryland's website, all this information is public information that is filed monthly with the Maryland Public Service Commission. I'll stop for some mathematical questions if there are any.
So a quick question. So theoretically, your goal is zero.
Yes.
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 Yeah.
If it were perfect, yes, it would be, you would be billing at weather normalized, but we have fluctuations in weather, fluctuations in energy efficiency, all, other things because it's full decoupling. So it could be either of those things, but focusing on like January and February, most of that was weather related.
And so for this calculation, when you're doing average class-based revenue, you're taking out, is this also incorporating weather?
No, it's weather normalized.
Weather
right?
normalized. So but you're taking out like unusual weather.
You would adjust because you're using 30-year weather to set your rates, right? So it's that 30-year basis that's in there. So they're weather normalized. So they're basically looking at historic, and that's how it gets set in a rate case. So that's what we're comparing to. So when it's out of the norm, right, that's when you see the plus and minus.
Can I ask a couple questions? How is it implemented on a customer by customer basis versus like across a class of customers? And then separate question across classes across different classes.
This is specifically for residential only. So each class has its own revenue, base revenue that's set in the rate case, right? That's by customer class. And then it's implemented, every customer gets the same rate. So it's really based on usage, right? So it's not like every customer gets, their own adjustment. It's on a class by class basis. It's set at that level.
Just one follow-up question. So even though the concept is to decouple revenue from sales, from the amount that a customer is using, the way it's actually calculated is based on how much that customer used in a month and then trued up to.
It looks at all the customers in that one class, and then you'll get your true up based on how much you used in the next month, if that makes sense. So it's all based on that rate. So this is on average. So if you were higher than average, you would get more than the $3.59. So it's not, each customer gets 359. That's an average customer using 811 kilowatt hours. If you used more, you would get more. So basically, there's, like an over under calculation, and you're utilizing that to set the next rate period. And then you're hoping to get back to zero, right? But you always have like an ongoing small true up. And then they set rate caps. Like in Maryland, you can only, because it's done monthly, you can only either add or reduce a bill by 10% of the current rate. So if the rate is 1 cent, you can only do it by like point, whatever that would be, 0.001. So there are limits. So for example, if you had to collect back a large amount, there's a cap on that. So you would just defer that out till the next period with you wouldn't get any return on that over or under balance either. Just kind of carries out to the next period.
Thanks for this clarification.
Okay, so moving on to the next slide, this, again, some benefits of revenue decoupling. It's intended to stabilize revenue, as we talked about, and it's based on test year, right? So when in Delaware, and because we still use historic test periods, it's based on that rate case. So it's historic, and it results from, rates approved in a rate case proceeding. As we mentioned, any under collections are returned or billed through customers through the mechanism. And for example, in periods of extreme warm summer or, really cold winter could result in refunds to customers. On the flip side, ongoing decarbonization leading to increased electrification could result in increased customer usage, kind of countering the trend of declining sales. So thus creating that potential benefit to customers in that the overall amount paid would continue to align with approved commission targets. And I think that's really the thought is like, it's not it's the intent is to get to the approved level of revenue, no more, no less, just what was approved in the rate case. So it does improve performance with our state programs. Again, this steady revenue stream benefits customers by enabling the company to support both directly and indirectly energy efficiency, DER, innovative rate designs like NEM, community solar, and EV that advance some of the state's public policy goals, but result in that decreased customer usage. So on the next slide, I think we talked about some misconceptions. And, historically, environmentalists and energy conservation advocates support decoupling, while, potentially consumer advocates representing utility ratepayers have opposed it, claiming it guarantees revenue levels to utility companies. However, when we kind of look at it holistically, the level of revenue is aligned with what was approved by the PSC. No more, no less. If we overcollect, we give it back. Undercollect, we collect it. It doesn't remove the financial risk or incentives tied to managing, operational spend, and doesn't guarantee a set return. It better aligns utility revenues. Again, we talked about the fixed nature of distribution system costs. Generally, they're fixed. Just going through my notes here, I have a couple more things. It stabilizes customer bills in extreme weather events, hot summer, cold winter. It hasn't led to, decreased operational effectiveness in any of our jurisdictions. And it doesn't guarantee the, return on equity. It's based on historical test years. So the utility has the opportunity to earn their ROE, but they have to do their job on maintaining expense levels and doing all those things to, opportunity to earn that. And I think just talking, about the budget billing, I think that staff mentioned, that too is a really good thing for customers, but that doesn't really stabilize revenue per se or give them refunds for, for extreme weather events. What it does is it smooths their bill out over 12 months, no matter what their bill is, but it doesn't take into effect, the actual extreme weather events that, in a revenue decoupling environment could reduce customer bills. So I said a lot of things, and I will take a breath and see if there's any questions.
So without bill stabilization such as this model, does that enhance the potential for the utility to bring in and or earn more
I don't think it enhances it, but it allows you to, right? I mean, because you're collecting on, in weather events, your sales are up because of weather.
And with the bill stabilization and adjustments, does that make the utility more exposed to the risk of weather swings?
I don't think that just makes you indifferent to the weather swings, right? Because I think it's the revenue stability that really keeps the utility, collecting what their revenue was that was approved in the rate case.
Well, you're allowed under the rate case to collect the revenues that you've targeted. But if the weather really swings and you're normalizing those swings for the customer, are you not putting more risk on the utility's financials?
I think it just stabilizes the revenue, so I don't know if it adds the risk. That's what the utility was approved to collect in revenue, so it doesn't make that doesn't get more risky.
Right. I guess I'm operating on the basis that, your test year is historical and the weather is tomorrow and the future.
Can I ask just a couple more? You had mentioned that I think in Maryland, it was approved along with a 50 basis point reduction in ROE, and then that was removed at some point in time. I was wondering if you could comment on both why it was included in the original and why it was later removed.
So I believe that it was included originally because they thought it was de-risking, some of the utility revenue. But kind of moving it forward, they didn't feel the need. And I don't think, and looking at other utilities that have decoupling, there aren't ROE reductions. That was just an original thought because that was approved back in 2007, right? So I believe that they don't believe that that's, true.
Okay. And then I think you mentioned that in one jurisdiction it's annual and one jurisdiction it is monthly. And I was wondering if you could just comment on how that works from the company's perspective and to the extent you can, how that appears to a customer.
So in Maryland, as I mentioned, that operates on a monthly basis. So the utility files, at the end of the month, they get all the information, they do the calculation, they file something with the commission, they have a compliance filing. So the commission has the opportunity to review the filing, but the company puts the rate in automatically, right? Unless there's something that they find wrong, then they would go back and correct it. I think the customer has more ability to understand the impact of that based on the more current weather. If it's, if that happens in January and then you get this adjustment on your bill in March, you can match it better, right? When you have the 12-month period, something that happened in January, and you're filing in, say, July, and you don't get approval till the next December, say, for 6 months to put that rate into effect, now it's a full year later. So I'm not sure customers can tie it together, although it does reduce potential fluctuations because you're looking at a 12-month calculation versus a monthly calculation that could be positive one month, negative the next month. So I think there's benefits to both. I just think it's really important customer education on understanding how it operates and really, helping customers make those connections.
Thank you.
Just a couple of comments, Madam Chair. I want to thank Delmarva for making this presentation. I had an opportunity to see it, and I thought it would be helpful for the rest of my colleagues to see it as well. And I really asked about this bill stabilization in view of the fluctuations from the last winter's utility bills. It was quite an uproar throughout the community about the bills that came in. I do have a question. Have you, of all of the states that have used this model or administered a BSA or a decoupling, have any of them abandoned it? And if so, why?
That I don't know, but we'll have to get back to you on that one.
Okay, that would be helpful to know. Beyond that, I'm going to just thank you again very much for bringing the subject matter. I know that the staff has issued a memo. I don't know, Matt, if at all you want to bring that forward to the table or just for our consumption.
It was really just for your consumption, Commissioner, and we haven't looked at this formally, for Delmarva in quite some time, but just wanted to provide some historical context of where staff and the DPA were at the time.
1 second, please. If I could, if you'll allow me, just like to read a paragraph from the staff's summary, if that's okay. Basically said the primary concern is stabilizing or leveling customer bills. Encouraging customers to participate in budget billing would result in more levelized bills. Staff believes a new approach to budget billing could result in higher participation. We found that the word budget is misleading to many ratepayers. They believe participation in the program is only available to low-income customers, as the impression is customers with fewer resources tend to budget those resources. Customer education about the program could result in increased participation. Additionally, staff would be interested in working with utilities and the DPA to determine if a change in frequency or timing of the annual budget billing over under collection true-up on customer bills is appropriate. I just wanted to share that as a working opportunity to find solutions for communities that are burdened with the fluctuations due to weather. Last thing I'll say is I think I've received something from Delmarva where you plan to mention something about additional resources available to low-income ratepayers next week. I don't know if anyone has information on that today, but I've received it, and I do hope I can rearrange my schedule to be in Wilmington when that is announced. No further comments, Madam Chair. Thank you, Matt. Thank you, Delmarva, very much. Appreciate it.
Our next meeting will be July 2nd.
Adjourn.